Well, hello. So I'm just kind of enjoying the first real, truly beautiful weather day that we are having in Boston. Decided to come work remotely down at the seaport. And it's just a wonderful day. Maybe I'll show some footage of what's going on down here and all the cool things you can see if you feel like coming to the seaport yourself. But also, part of the reason why I am making this video is to do part two, where I'm going to now try to explain to you the ins and outs of stock options, at least from the perspective of a company or an employee issuing stock options. So, we're not talking about the investment part of this where people buy and trade options on the stock exchange. That's not what we're talking about here. We're talking about a company issuing stock options to its employees, contractors, advisors, so on and so forth. And what are the mechanics of that? So in the first video, which I will link below and also put a link to it, somewhere here or there, or you may have come to this one through that video. But in the first video, I talked a little bit about the sort of philosophy behind stock options, making determinations of when to issue them, or if you're on the receiving end, when to accept them, how to determine the value for yourself, as well as, thoughts on how you want to deal with exercising options when you have them. For this video, I want to get into like just the straight up nitty gritty, the exact process of how it generally works in order to both issue stock options if you're on the company side and how to exercise stock options if you're on the recipient side. Now, I want to preface this by saying that none of this is legal advice. This is purely educational. I'm just sort of explaining the process of how things work. Your circumstances and situation may be different, whether you're the company issuing or the employee receiving. So you always want to make sure to check with a attorney regardless of what situation you may be in so that you can determine for yourself exactly what needs to be done. But I'm just going to explain to you the typical steps of how this happens. So this all starts with a stock option plan. It's usually referred to as an acronym, an ESOP, Employee Stock Option Plan. And they have names. It could be company name, stock option plan 2024, or it might get creative, or if there's multiple plans, there might be, multiple different names, plan A, plan B, and they may each have some specific elements to them that deal with how many shares are available, which shares are available for issuing. Maybe there are different classes of shares that will be issued to different levels of employee, all sorts of things that can happen. But step one is to have an ESOP in place. And typically the way that's done is both the shareholders and the board of directors vote or sign off on a piece of paper that effectively makes the vote happen. And that establishes the ESOP, states the name of it, approves the plan itself and the language that is contained in it. Typical ESOP plans are fairly long, anywhere from 10 to 20 pages, possibly longer, depending on the complexity. And it also sets a number of shares that will be included in that plan and the specific class of shares that will be included if it's something other than just normal, straight, common stock. So once you have that established, the next thing that you need to do before you can issue shares depends on the state of where your company is. And when I say state, I don't mean the actual state of incorporation like Delaware, Massachusetts, California. I mean the particular status that your company is in. And this is sort of a rule of thumb type of thing, is that if your company has not done a priced round, meaning a round of investment where preferred stock is issued in exchange for a certain amount of investment that creates a valuation for the company. If that has not happened yet, typically you would just issue stock options, and the exercise price, or sometimes it's referred to as the strike price, the amount of money that a person has to pay in order to exercise a stock option, that is typically the par value of the shares of when the company was established, whatever's written into the charter. In the alternative, if you have had a priced round, if you have accepted investment in exchange for preferred stock that has a valuation attached to it, then you have to have what's called a 409A valuation. This is 409A is referring to something in the tax code, and it is essentially a official valuation that is done by maybe an accountant or someone else. If you have a Carta account where you're keeping track of all the equity that's been issued and everything else, Carta actually does it directly as part of one of their services. But generally, the way that it would work is you would have a 409A valuation. Someone will say, this is what the company is actually worth today, and therefore what each share is worth. And that becomes a strike price. And there are certain rules that go into when you have to do a 409A. Generally, it's before you issue the first set of options or shares, after a priced round is completed, and then normally you have to do it every year unless there is some type of event that you could reasonably believe will affect the value of the company. So you might have a 409A, and then 2 months later, something amazing happens and the company takes on all sorts of customers and does all sorts of business. It's now obviously worth a whole lot more. And so you should do another 409A valuation after that major event occurs before you try to issue more shares out to people or more options out to people. So from that point, it's purely mechanical in terms of providing the recipient a copy of the stock option plan so that they have it, and providing them with the information that they need in order to understand what they're receiving. So they'll get a grant notice and a grant agreement. Typically, this is how it's done, where it says, here's what you're getting, here's what the strike price is, here are any terms that go along with it, like if there's vesting involved, where you earn a little bit of it each month over a period of so many years, or whatever other specifics are involved in the grant that is being done. And then that person signs off on it, and everything is recorded, and you maintain track of things. And if the person's working, they are receiving their options, if they're vesting over time. And then once they are fully received, then we kind of get to the last step of things. Well, what happens if you want to exercise it? Well, to understand that, you have to understand that there are two basic type of stock options. You've got ISOs and NSOs, incentive stock options, which are only available to employees, and they come with some extra tax benefits. And I may do a video breaking this down at some point, but I'm not going to go into it now. It would just make it too long, too overly complex. But incentive stock options are only available to employees because of the beneficial tax treatment that they receive when it comes to exercising them. The alternative is a non-qualified stock option, an NSO, and those are granted to people who are not employees. So these might be contractors, they might be advisors, or someone else who is just not a actual W-2 employee of the company. Incentive stock options have to be exercised within 90 days of the person no longer being an employee of the company. And this is part of the rules that go along with getting that beneficial tax treatment that comes with an ISO. Non-qualified stock options can have a vastly longer exercise period. It can be years for the exercise period for a non-qualified stock option. So in those situations, the trade-off of not getting favorable tax treatment upon exercise is that the person has much longer to exercise them. And there are situations where sometimes if someone wants a longer exercise period, there are ways of converting an incentive stock option to a non-qualified stock option. And of course, the employee has to recognize and understand that in doing that, they'll lose their favorable tax treatment, which could have some negative consequences to them later on down the line. But as long as everything is explained and they have an opportunity to consult with a tax professional and determine exactly how this is going to work out for them, hey, everything should be all set. So in the case of exercising it, generally what happens is the person sends in their exercise notice along with a check for the amount, the strike price times however many options they're exercising. They could do some or all, There's generally no requirement that the person has to exercise either all or none. And this is the same whether it's an ISO or an NSO. And after that is done, the company processes that information, issues a stock to them. That person now is a actual shareholder in the company. So they don't become an actual shareholder with shareholder rights until the moment they choose to exercise the stock option, pay the money that goes along with the strike price, and then the company issues them their shares. And once that's done, that's pretty much it. And so, from the recipient side, you just need to know that you have these documents you'll receive in the beginning that will tell you what you're receiving, how much you're receiving, and the value of it. And then when it's time to exercise, you just need to know that you have to send in the paperwork with the check for the right amount of money, and you'll get shares. And then on the company side, of course, the process is exactly the same, but you need to make sure that you have done your 409A valuation, that it is up to date as required, and that the strike price is correct, that you have made sure you have enough options in your option pool to be able to actually issue these out to someone. They have to be there before you issue them. And then when the person does get ready to exercise, that you process their payment, process their exercise, and account for that on the books of the company, that the options have now been exercised and shares have been issued in their place. And once those shares are gone, they're gone. So it's not like the option could be reissued now, because the option is attached to shares, and once it's been exercised, it's now gone. It's been replaced by shares in the company as opposed to options to gain shares. And about the only other thing that the company should be aware of and thinking about in this process is making sure that they are also following the rules as they relate to employees or non-employees, and therefore incentive stock options and the exercise period allowed by law for that, as well as non-qualified stock options and the exercise period allowed by law and the plan for that. Beyond that, as long as your attorney has drafted your plan with the things that you want in mind in place, and you are aware of that, and you refer to your legal counsel as necessary, everything should be all good. So I hope that this was helpful to you in explaining the process and the mechanics of going through issuing or receiving and exercising stock options. And if it was helpful, please like and subscribe. It definitely helps the channel to grow. It helps these videos get in front of more eyes, and makes it so that I'm able to try to educate more and more people on how this whole startup world operates. So, as always, thanks for watching, and I will see you next time.